part 1, part 2 of the chapter first. So to get the answer that what is the role of the evidence law, to get the answer of the two portion arranged in the part 1, that the whole evidence law is basically a fact-finding inquiry in the criminal or the civil trials, or you can say in the judicial inquiries. So to finding the truth, to deciding the controversial facts, we take the help of the evidence law, and accordingly what facts are admissible, what evidence are relevant, all these things has to be determined by the law of evidence. And that body of rules is known as law of evidence. Then we discuss that how the law of evidence have the different significance in two major judicial system prevalent all over the world. One is the adversarial system, that is related to common law system or common law countries like India, Britain, Sri Lanka, Pakistan, etc. And another is the inquisitorial system, in which judge has the active role, judge asks the question, all that thing we discussed. Then we had the discussion on that the Evidence Act and its development. Its development before the statute was enacted in 1872, and the development after the act has been enacted. So the pre and the post statutory development of the Indian Evidence Act. Now the remaining portion of the chapter 2, I would, try to complete in this lecture, because, 1 week has, we started class, I think, from Monday. So this is the end of this week. And so I would try to finish this whole chapter in this lecture. Or if it is some portion is left, so maybe we will, take the next lecture also on this point. Now that we even discussed the different type of the, provisions that are in the Indian Evidence Act. Then we even discussed that how to read the statute, what are the important terminology related to statute. Now the first I'm taking the scheme of the Indian Evidence Act 1872. The Indian Evidence Act 1872, the bare act that you have either in the hard form or in the soft form. And in the last class also I told you that this act was nicely drafted by Sir James Fitzstephen, or you can say James Stephen. And the whole law of the evidence, you can say the every rule that he inspired from the Taylors, or the law of the evidence that was prevalent in the England. And he composed it into only 167 sections. Okay. Now, if you see that the whole Indian Evidence Act has 167 sections, and it is divided into 3 parts. The first part is part 1 is the relevancy of fact. The second part, this thing that you even can write it, so that it would be very helpful even for the the competition examination also. The second part is on the proof, and the third portion is the production and the effect of the evidence. As the name suggests, that the first portion is related to relevancy of the fact. So whatever the discussion we had on the section 136, that only the relevant, fact has to be adduced, only the relevant things has to be proved in an inquiry, and judge has to decide the admissibility. So that relevancy has to be determined according to part 1. Then how that relevancy and what all other things has to be established, that is done under the chapter 2. And how much effect it had, and other aspect related to part 3. The part 1, if you overall see, that it has 11 chapters. Part first has only 2 chapters, first chapter and second chapter. The first chapter is preliminary one. You can even, flip the pages as I speak. The first chapter is preliminary from section 1 to 4. Section 1, as in the last class also I discussed, that related, the first section related to source, title, extent, and the commencement. And 2-3 other section like the definition section, section 3, presumptive section, section 4. And then the second chapter started from section 5 to 55. This second chapter is the most important chapter. And our second chapter of the syllabus is based on this second chapter of the Act. And that is very, very exhaustive. We have taken, the many provisions from this chapter second, but not all. Now, the second chapter of the the statute 1872 has many groups. The similar sections now arranged in groups also. From section 5 to 16, you will find the different provision related to various type of admissibility, like section 6 res geste, like section 7 the occasion, effect, etc. Section 11 the plea of alibi. And from section 17 to 31 is in a one group that is known as admissions. Confession is also the subcategory of the group admission. What is admission? What is admission? When you, in a trial, there is a question of something, some particular fact, and before the trial, somewhere else you have admitted that fact, is known as admission. Okay. Group second is related to the statement of the person that cannot be called as witness. Section 32 to section 33. There is some possibility that certain person cannot be called, or the statement of such person cannot be recorded or cannot be examined before the trial. कैसी सिचुएशन हो सकता है जिस आदमी ने वो स्टेटमेंट दी या इन्वेस्टिगेशन के दौरान वो स्टेटमेंट उसने दी, he has expired, he is no more. So that is section 32 clause 1 dying declaration. Maybe he's in the another country and it is not possible to call that person. So the various the circumstances under section 32 has been prescribed. 8 type of the circumstances you can find it. Okay, I'm not going much detail in that, because when we will discuss this second chapter, then we will have discussion on that also. The third group is related to statement made under special circumstances, and section 34 to 38 basically comes under this group. Here when you are making the entries in a particular record, map, etc., so those special statements are covered under this particular group. See, this group are just to you can say the purpose of the naming the certain section under one group is for making it convenient to arrange the similar section, similar type of the section. Okay. Group 4 is related to how much of a statement is to be proved, section 39. Group 5 is related to judgment of the court of justice when relevant, section 40 to 44. And in the, maybe in the LLM entrance examination or in the judicial examination or other competitive examination, you will find many questions from Indian evidence law directly related to the particular section or to its illustration. Okay. In the multiple choice question, generally the question is asked from either directly from the sections or from its illustration. So sometimes the previous judgment is also may be relevant. Suppose there is a trial, how it is possible? Suppose there is a trial and the trial is about, the entitlement on a particular property, whether a particular property A is entitled or B is entitled. And in this trial, B produced a judgment that before this whole inquiry, judicial inquiry, there was another case and in which I fought against the C. And in that case, I won, and this is the judgment. So whether this particular judgment would be relevant or not relevant, because the whole, relevancy is from section 5 to 55. So that is section 40 to 44 related to judgment of the court of justice when relevant. Then the group 6 is related to opinion of the third person. Suppose in a murder trial, whether A killed B or not, the question is whether the bullet has been fired from a gun. And on that, the fire expert statement, because the fire expert was not present at the scene of the crime, he has not seen the occurring the crime, but as an expert, as a third person, his opinion may be relevant. So when it is relevant, related to fingerprint impression, relating to handwriting, so all those doctor statement, all those persons who are expert in their field, they are known as third person. So their statement, because they are strictly not from accused, not from victim. They are neither accused nor the victim. So that's why they are known as third person, or you can say expert person. So the opinion of the third person when relevant is covered under section 45 to 50. Only those opinion can be relevant and that can be admissible, because the relevancy is the larger sphere and admissibility is the smaller sphere. From the section 136, we have learned that in a judicial inquiry, everything has to be proved by using the relevant facts. And for the relevant fact, we can give the evidence. And what is relevant? That those facts that are made relevant under the chapter 2 of the Indian Evidence Act, that means from section 5 to 55. Now the seventh group under the chapter 2 is that when the character is relevant. So the character when relevant is from section 52 to 55. And there you will find that in the criminal trial, if you want to adduce this fact that just this person who in this particular inquiry, the allegation was against A that A raped the girls B. So this person B has already molested some another girl. So this statement that refers to the character of the accused is not relevant. And when it is not relevant, that means it is not admissible. It cannot be made admissible. आप उसको एड्यूस करना चाहोगे उस चीज को, किसी आदमी को बुला के बताओ इसका कैरेक्टर कैसा है, सेकंड पार्टी विल ऑब्जेक्ट इट एंड देन अकॉर्डिंगली अंडर सेक्शन 136 जज हैज टू डिसाइड द एडमिसिबिलिटी. Okay, are you getting? So there you, from section 52 to 55 you will find. When we will discuss in the detail, you will enjoy this thing. But now along with me you can flip your pages and you can see all these sections, so that after the classes you can revise it. So this is the part 1. The part 1 of the Indian Evidence Act is basically related to relevancy of the fact. It has 2 chapters. The first is preliminaries from section 1 to 4. The second chapter is of the relevancy of the fact, and it has 7 groups from section 5 to 16. It is not under any group, and then from section 17 to 31 under the group admission. Then section 32 to 33 is the statement of the person who cannot be called as witness is relevant. Then section 34 to 38, the statement made under special circumstances. Then group 4, how much of the statement can be is to be used, section 39. Then chapter 5 is the judgment of the Court of Justice when relevant, section 40 to 44. And then the chapter 6 is the opinion of the third person, that means the expert opinion when relevant, section 45 to 50. And then group 7 is related to character when relevant, section 52 to 55. In these sections from 5 to 55 under various groups, the relevancy is determined. Some statement, some judgment, some opinion, some character are made relevant, and some are made expressly irrelevant. Okay, some are maybe relevant but expressly declared to be inadmissible. So only those that are made relevant and has not been expressly declared as inadmissible are, or can be used in a judicial inquiry. Okay, anything that you want to ask from this part first? No? Okay, I'm taking that second part. Part 2 of the statute, that means the Indian Evidence Act 1872, is related to proof, and it started from chapter 3, chapter 4, chapter 5, and chapter 6. 3, 4, 5, 6, that means 4 chapters. Chapter 3 basically related to maybe certain facts are relevant, but that need not to be proved because that is in the public domain or by some other region. So the first, it starts from chapter 3. The first portion is chapter 3, the fact which need not to be proved. Here, the part 2 of the Indian Evidence Act is not related to relevancy. Relevancy is already decided. Maybe that is relevant, but that need not to be proved. Section 58, 56 to 58. Certain fact that, on the particular Sunday it was holiday, no need to prove. That this is the Indian flag, no need to prove. Okay, so many things you will find, go into details. Then chapter 4 is of oral evidence. As in the last class also we said that the evidence may be of 2 types, oral evidence and documentary evidence. And documentary evidence after the amendment also include electronic evidence. Digital जो हमारा जो होता है उसको बोला गया है electronic evidence. Okay, so electronic evidence is also subcategory of the documentary evidence, because the definition was so strict of the documentary evidence, so it was amended in the definition, and now it is that the evidence may be oral or documentary. Oral, that can be given by a person by speaking, and the documentary that have some type of the material printed on the something or in the electronic form that present in the digital form. Okay, so that material is the documentary. So the chapter 4 is related to oral evidence, section 59 to 60. that who can give the oral evidence. And where, if you remember, in my last class, one statement that the cardinal principle is that if it is about a fact that can be seen, so the person who saw it, and other person who did not saw it but who hear from that person who actually saw it. So suppose there is a trial of murder, and the allegation was against A, that whether A has murdered B or not, and some person C saw that A was stabbing knife to the B. So this C who saw this particular incident can give the evidence that he saw that A stabbed B. But after that, suppose the C person told to his family member, maybe his father D, and D told to his friend E. So this E or D cannot give the evidence, because this is the something that can be seen, because stabbing is the incident that can be seen and they have not directly seen. So this type of the evidence is known as the hearsay evidence. The evidence by D and E is the hearsay evidence, and the evidence by the C is the the proper evidence. And so he can give the evidence. So who can give the oral evidence and all other rules related to oral evidence is under chapter 4 of the Indian Evidence Act, section 59 to 60. तो इस section में सब कुछ. Okay, then definitely अब oral evidence है तो documentary evidence का होगा. So chapter 5 is related to of documentary evidence, and there the documentary evidence also include the electronic evidence also. Then the documentary evidence, suppose if it is the civil inquiry about the breach of the contract, or some other, like in the Muslim marriage it is about their nikah. So how much the amount of the door, or in the contract what was the condition. So this thing can be proved by that document. डॉक्यूमेंट ले आओ, उसमें सब कुछ लिखा है, there is no need to explain, because that document is self-explanatory. So that document can be given, and this document, suppose, is not maybe it is stolen or it is already destroyed, so its photocopy, its other things is possible. So the document in itself, original document, is known as the primary evidence, and its photocopy or it's in any way it's reprint is known as the secondary evidence. So primary evidence, secondary evidence. Then there are certain documents that are present in the public offices, that is known as the public document. So all these types of the terminology you will find. So chapter 5 is of the documentary evidence, and from section 61 to section 90, capital A, because through when this IT Act was passed to amend the provisions to include the electronic evidence, this after 90 there is 90 capital A. So section 61 to 90A is related to documentary evidence, where you can find two groups of related to public documents, section 74 to 78, and presumption as to the document, section 79 to 90. Then the chapter 6, the you can say the fourth one, the fourth in the part 2, and the numbering is the chapter 6 of exclusion of oral or documentary evidence. Like the content of the document has to be, for the content of the document, oral evidence cannot be admissible. Like document में क्या लिखा है, उसका oral evidence क्यों, उसको document ही ला दो ना, जब साहब सीधे पढ़ लेंगे उसको. So these type of the rules are from section 91 to 100. So this is about the part 2. So the part 2 of the Indian Evidence Act has 4 chapters: chapter 3, chapter 4, chapter 5, and chapter 6. Chapter 3 is related to the facts that need not to be proved, section 56 to 58. Chapter 4 is related to of oral evidence from section 59 to 60, and chapter 5 is related to of documentary evidence, section 61 to 90A, and then chapter 6 related to of exclusion of oral or documentary evidence from section 91 to 100. Now come to the third part. The third part, has the remaining sections, that means 67 sections, and it is from chapter 7 to 11. So the name of the part 3 is production and effect of evidence. Production and effect of evidence. Chapter 7 is about the burden of proof. That means who will prove, how much one has the burden to prove. So generally, it's very simple thing. Like sometime in a normal situation, if these rules were not there, it may create the confusion. Suppose there is a trial. The question is that whether A murdered B or not. So the prosecution side saying that B, you prove that you had not murdered A. The defense side said that you prove that I, that means the B, murdered A. Now the question is, who will prove? Suppose you have read the general defenses, the intoxication, even the private defenses, section 96 to 106. So in the self-defense, this person has killed. The exceptions of section 300, grave and sudden provocation, that I killed this to the grave and sudden provocation. Now who will prove that there was a grave and sudden provocation? So the burden of the proof, to whom there is the burden in a trial, because in any judicial inquiry, because we have or following the adversarial system, so both the party are at the opposite side, and the question that who has the burden to prove is decided according to rules present in the chapter 7. If you very interesting, one is known as the burden of proof, section 101. Another is the onus of proof, section 103. Burden of proof is always on the person who go to the court for getting the relief in his side. So if you apply this in the criminal side, who go to the court? जिसके साथ अन्याय हुआ है, जिसके साथ crime हुआ है. So the prosecution side has to prove all the things. All the elements of the crime has to be proved by the prosecution. On them, there is the burden. The burden may be the strict or the, relaxed one, as you know in the criminal law. In the criminal law, the burden कितना होता है उनको prove करने का? Beyond reasonable doubt. In the criminal law, the burden is heavy, beyond reasonable doubt. But the burden is on the party who go to the court, as according to section 101. And in the civil cases, from the preponderance of probabilities. The burden is very relaxed, the preponderance of the probability. But again, the burden is on the person who go to the court. कौन जाता कोर्ट में? प्लेंटिफ, वादी, और उसका उत्तर देने का होता है रेस्पोंडेंट, प्रतिवादी. So the burden under the chapter 7 is decided from section 101 to section 114A. There is all provision related to this. Section 103, that is onus of the proof. So onus of the proof, suppose there is some presumption or there is related to some particular fact. So to that, the person can give the evidence, but through the presumption, it keeps on changing. Like now, there is the presumption that when the prosecutor says that she was not consented for the sexual intercourse, the court shall presume that she was not consented. So shall presume word is used here. And in the section 4, we will discuss that there are 3 types of the presumption: may presume, shall presume, and conclusive presume. May presume is relaxed, or you can say very liberal or very, relaxed one. Then shall presume से भी hard, and conclusive proof is most hard thing. May presume, the court may presume or may not presume. Shall presume, court has to presume, but that can be repeated. In may presume, when you presume, the court presume, the rebuttal is possible. Or maybe court will not presume, nahi hum to nahi manenge. In shall presume, court is bound to presume that thing, but the rebuttal is allowed. And in the conclusive proof, the court will presume and even the evidence will not be allowed to rebut it. Like the section 112, presumption as to the paternity. Okay, that I think we discussed in last class. So the chapter 7 is related to the of burden of proof. Then there is chapter 8. And chapter 8 is known as estoppel. And you can say the chapter 8 basically substantive in the nature because it creates the right. So chapter 8 estoppel from section 115 to section 117. Then there is chapter 3. Sorry, chapter 8, chapter 9. Sorry, chapter 9. After chapter 8 estoppel, there is chapter 9, and this chapter 9 is related to of witnesses. Who can be witness? Like there is one chapter in our syllabus, the dumb witness, child witness, hostile witness, etc., etc. We have. So this chapter 9 is related to of witness, and it run from section 118 to section 134. So all rules related to witness. Then the next is chapter 10, and the chapter 10 is of examination of witness. How the examination will be done, what question can be asked, like the leading question cannot be asked in the in the examination. So the examination, section 137 and 138, if you combinedly read, that there are 3 types of examination in chief, cross-examination, and re-examination. And order is first is examination in chief. In the court, generally, the lawyer says chief हो रहा है अभी, फिर cross examination cross हो रहा है, and then re-examination if it is. So cross examination in chief कौन करेगा? दोनों जो पार्टियां एडवर्सियल सिस्टम में जाती दोनों के विटनेसेस होते हैं. क्रिमिनल साइड में आफ्टर द इन्वेस्टिगेशन पुलिस विल रिपोर्ट ए चार्ज शीट, एंड दैट चार्ज शीट इज फाइल्ड बिफोर द मैजिस्ट्रेट, बिफोर द कोर्ट, अंडर सेक्शन 173 ऑफ द CRPC, क्रिमिनल प्रोसीजर कोड. चार्ज शीट फाइल होगी. इन दैट चार्ज शीट what offense, how it has been committed, who are the witnesses, their name has been written, the statement of the witnesses, all those things would be written that are sufficient to incriminating the accused. So their witnesses name, the witnesses list is written, and now these witnesses has to be examined before the court. Okay. Similarly, in the defense also you can name the witnesses. In the civil trial also, the name of the witnesses are in their respective, the plaintiff and the, you can say, WS. Now, these witnesses has to be examined. How it has to be examined? That the whole procedure is under chapter 4. Impeachment of the credit. Leading question cannot be asked. All these type of the rules, etc., are under the chapter 10 of examination of witness, section 135 to 166. And chapter 11 is of improper admission and rejection of evidence, section 167. Only one section under the chapter 11. So this is the whole scheme. Now you have observed it that relevancy is only under chapter 1. Chapter 1 is relevancy. Chapter 2 is of proof. क्या prove करना है, क्या नहीं करना है, कितना जो है क्या oral evidence है, what is documentary evidence, how which oral evidence we can prove, which documentary evidence we can prove, how that has to be proved. Chapter 3 is related to who has the burden, rule of estoppel, who can be the witness, how that can be examined, etc. So this is the whole your Indian Evidence Act. Now come to the the question about the certain terminologies that are used here, like the fact in issue, etc. I'm again reading the section 136 because that is very important, and one should start the discussion from section 136 of Indian Evidence Act to teach the Indian evidence law. See, section 136 it say, if you have direct, you can also, read with me, that judge to decide as to the admissibility of the evidence. So who will decide that whether this particular evidence is admissible or not? Suppose in a trial, prosecution want to produce a evidence. The opposite side may object. No, sir, this cannot be allowed. Now, if judge on this spur of moment think that, okay, it is really, it is not relevant. So say objection sustained, otherwise objection overruled. So I think ये चीजें आपने सुनी है. So basically, who is deciding? Judge. So judge to decide the admissibility of the evidence. Now I'm reading it. When either party, like in the criminal trial, prosecution or defense, in the civil, plaintiff or the respondent, in the appellate matter hoga to appellant and the respondent. When either party propose to give evidence of any fact, the judge may ask the party proposing to give the evidence in what manner the alleged fact, if proved, would be relevant. So judge has the power to decide, but that power also is related to relevancy of the fact. That if you prove this fact, the evidence that you want to adduce, the evidence you want to give, वो कैसे relevant होगी भाई साहब? Okay, and how it would be relevant? That is determined from section 5 to 55. So the other party who want to adduce the evidence and against whom there was the objection and judge is deciding and just ask the जज ने वैसे जज साहब ने कह दिया कि नहीं हो गया तो ठीक है, लेकिन सपोज जज साहब ने कहा कि ये कैसे रिलेवेंट होगा. ही आस्क्ड फ्रॉम दैट पार्टी हु गिविंग दैट एविडेंस that how it would be relevant. So this person, this party, his lawyer has to prove or has to give the justification that under this section 8 or section 9 or whatever section it is relevant, and judge shall admit the evidence if he thinks fit, that if it is proved it would be relevant, otherwise not. So only the relevant fact has to be proved, and then there is a question related to the particular evidence. On that has to be decided by the judge by seeking the justification that under which provision it is relevant. Suppose there are the one fact, like the second portion of the section 136 I'm reading. If the fact proposed to be proved is one of which evidence is admissible only upon the proof of some other fact, such last mentioned fact be proved before the evidence is given of the fact first mentioned, unless the party undertake to give proof of such fact and the court is satisfied with such undertaking. So suppose there is a particular evidence, a particular fact one party want to propose, and this fact is admissible only when there is another fact that has to be proved. Suppose there is a particular statement of a person in a trial of, or you can say in the trial of a rape or in any other trial, there is a question, one statement want to prove, and in that statement this person A was saying that this particular crime was committed by B. Now because, and this person want to prove this statement as a dying declaration. So to before proving that it is dying declaration, before proving this statement before the court can ask that first you prove that this person is dead, this person is no more, or maybe first he allowed to prove this statement and then asked to prove that this person is no more. Okay, in the illustration you can read that it is proposed to prove a statement about the relevant fact by a person alleged to be dead. Which statement is relevant under section 32? The fact that person dead must be proved by the person proposing to prove the statement before evidence is given in the statement. The third portion is that if relevancy of one alleged fact depend upon another alleged fact being first proved, the judge may in his discretion either permit evidence of the first fact to be given before the second is proved, or require evidence to be given of the second fact before the evidence given of the first fact. Okay, so if there are two facts and the relevancy of one alleged fact depend on the another alleged fact, here both facts are alleged, so again the judge can permit it either to prove first or to second. Now the question is, suppose judge in a trial, you are the lawyer, you are the counselor, and your opposite party, they adduced a evidence, you objected. No, this is not relevant. Judge intervened, just asked, or maybe just said that objection overruled. Now in the appellate court, you proved that this was actually improper evidence because it is not relevant under any of the provision of the section 5 to 55. So what will be the consequence? Basically, the simple question is that section 136 require that only relevant judgment is admissible. That means the relevant fact is only the proper evidence. So what would happen that if there is the improper evidence is given, what would be the fate? The answer lies in the section 167. You know, this is the natural corollary of the section 136. कोई पूछ सकता है section that sir 136 में judge admissibility decide करता है और वो देखता है कि अगर relevant है तो allow करेगा, admissible करेगा, नहीं relevant है तो नहीं allow करेगा. Suppose करो judge ने गलत कर दिया because the error can be committed by any person. So judge is also there. So suppose judge wrongly decided that it is relevant. So what would be the consequence? So the consequence is on the section 167. Or you can say sir उससे trial दोबारा होगी या क्या चीजें होंगी? Section 167, or you can say the whole chapter 11 is related to this, that no new trial for improper admission or rejection of evidence. The improper admission or rejection of evidence shall not be ground of itself. That means only that there was an improper admission और improper rejection. आप एविडेंस देना चाह रहे थे, रिलेवेंट था, जज साहब ने कह दिया नहीं, जोश में, अब आप क्या करो? तो only on this ground that the improper admission or the rejection, the new trial cannot be done, or reversal of decision in any case cannot be done. कब? When if it shall be appear to the court before you raise the objection. अब इस केस में आपने appellate पे किया तो appellate court के before. That if we remove that improper admission or rejection, are there sufficient evidence to satisfy or to justify the decision? If there are sufficient evidence to justify the evidence, yes. If there is not sufficient evidence to justify, then maybe. Okay. So if it shall be appear to the court before which such objection is raised, that independently of evidence objected to and admitted, there was sufficient evidence to justify the decision, on that if the rejected evidence had been received, it would not have varied the decision. So उस केस में no new trial. Okay. Now there is another question that may arise, that as such the relevant facts that you have to, or the evidence of relevant fact you have to given. Sometime there may be necessary that judge has to, for finding the truth, has to ask something more also. And so that power is given under section 165. That judge can ask even the irrelevant question also. Okay. Section 165, the judge power to put question or order production. The judge may, in order to discover or to obtain proper proof of the relevant fact, ask any question he pleases in any form at any time of witnesses or of the parties about any fact relevant or irrelevant. So judge may ask. So I think from this section 136, these two questions that may be in your mind, I have answered. Now, what is the relevant? For that, we have to take out the relevancy from section 5 to 55. Now come to the time is, I think, over. So now, uh, is there any class now, or can I continue? Yes, guys?
We have class, sir.
Okay. Okay, no issue. So the thing that we had to discuss, like the fact, relevant fact, etc. After that, we can, like I use that the relevant fact. Now, question is what is fact? So all these things we has to discuss, and we will discuss in the next class. So please, this is your homework. You have to read maybe 3-4 times section 3 and the definitions provided there,